morning, everyone. I'm Corey Lacey from the Illinois Soybean Growers, and I'm really excited to have you all join us today for the first 2024 the first part in our 2024 webinar series, Pesticides, the ESA and You, a look at the EPA's new ESA FIFRA policy, how we got here, and where we're headed. Brigit, do you want to hit the slide?
Absolutely. Oh, goodness. There we go.
So before I introduce our speaker, I just want to go over some kind of housekeeping. There will be a Q&A at the end during the webinar. At any time, you should feel free to hit the Q&A button at the bottom of your screen and submit a question. We'll review that, and either Brigit or our panelists will be happy to answer questions. So Brigit Rollins attended Simona State University, where she earned a Bachelor of Arts in Environmental Studies. After graduating in 2015, she started as a law student at Lewis and Clark Law School in Portland, Oregon. While at Lewis and Clark, she worked as a student clerk for the Western Resource Legal Center, where she worked on cases assisting small ranches, farms, and municipalities. During her time at Lewis and Clark, she also interned with the California Farm Bureau Federation, where she focused on Environmental Species Act and water law issues. Since then, she's joined the National Ag Law Center full-time in 2019. Brigit covers a wide range of agricultural law topics ranging from liability issues to lab-grown meat. However, her primary focus is environmental law as it intersects with agriculture, which is what she'll be presenting on today. And with that, Brigit, I'll hand it off to you.
Wonderful. Thank you, Corey. Good morning, everyone. Thank you all for joining us at 7 a.m. Really appreciate you all coming out. So I've got a lot of information to cover, and I'm going to do my best to make it understandable and hopefully palatable for the time of day. So I'm going to go ahead and get started here. So yes, again, today we're going to be talking about pesticides, the ESA and You, taking a look at EPA's new ESA FIFRA policy. Hopefully some of you are at least a little bit familiar with this new policy, or at least are aware that EPA is sort of taking this new approach. So we're going to go ahead and break that down today, what we know so far, what we don't know yet, and then give you all some time to ask some questions that I will do my best to answer. Just very briefly, for those of you who are not familiar with us, I am a staff attorney with the National Agricultural Law Center based out of Fayetteville, Arkansas. We are the nation's primary source for agricultural and food law research and information. We cover all kinds of legal topics related to agricultural and food law. So I am our environmental law attorney on staff, but we have attorneys that handle all kinds of different areas. So if you haven't heard of us before or are not familiar, feel free to check us out. We're here to provide resources and answers to you all. So without further ado, just very briefly, very quickly, in case you are really just not sure what is going on here at all. Early in 2002, so about 2 years ago, EPA announced that it was going to be developing a new policy to help the agency better comply with the Endangered Species Act, or the ESA, when it was taking actions under FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, which is the statute, the primary federal statute regulating pesticide use in the U.S. We'll cover it in more depth later on, but EPA has really struggled to comply with both statutes at once for the last 40 years or so. So a couple years ago, they announced that they were going to be taking new steps to try to kind of bridge that gap. At the time, we didn't really know very much about what EPA was planning. Over these past 2 years, they've released more and more information, and it looks like the policy approach they're developing is sort of focused on creating what EPA is calling early mitigations that they're sort of developing in an effort to reduce pesticide impacts to species that are protected under the ESA. However, what that seems to be shaking out to, if the policy is sort of implemented as it's proposed, we're going to be seeing a lot of new restrictions across a variety of pesticide labels. And at this point, it seems like most pesticide users would be impacted. So that is, in a nutshell, what is going on. And we're going to do our best to kind of dig into this today, take a look at both the ESA and FIFRA, the different statutes at play, how they sort of intersect and interact. We're going to take a look at how we got to where we are, what we know about EPA's new policies so far, and then just sort of take a look at what's coming down the road. So with that, we're going to start first with the ESA because I do think understanding how the ESA works and sort of what EPA's responsibilities are here are really useful for understanding sort of what the agency is trying to do and kind of hopefully help us ask whether or not we think that their new policy approach is actually satisfying the agency's ESA duties. So very briefly, the Endangered Species Act was passed in 1973. It actually just turned 50 last month. Uh, and the primary goal of this act, and I think most of us are pretty familiar with this, the primary purpose of the ESA is to protect endangered species, or more specifically, to conserve those species, threatened and endangered species, and the ecosystems on which they depend. So that's, not only does the ESA function to protect threatened and endangered species, but it also works to protect some of those habitats and ecosystems that those species depend on. And that's certainly going to be relevant to what we're talking about today. Uh, the ESA is primarily administered by Fish and Wildlife Service and National Marine Fisheries Service, collectively the services. Uh, these agencies are responsible for identifying and listing species, adding them to the list of threatened and endangered species, and for designating what's called critical habitat, otherwise known as those ecosystems on which our threatened and endangered species depend. Um, and very critically, once a species is listed under the ESA or once critical habitat has been designated under the ESA, those species and those habitat areas receive ESA protection. And the two primary ESA protections that are really going to be relevant here are the prohibition on take and the duty to consult. So the prohibition on take is the one that people tend to be most familiar with. This basically says that once a species is added to the endangered species list, it's a violation of the ESA to take a species. And take is very broadly defined under the ESA. It includes harassing, harming, pursuing, hunting, shooting, wounding, killing, trapping, capturing, collecting, or attempting to engage in any of that conduct. And then some of those terms are even further defined very specifically. Harm, under sort of that take definition, is defined as an act that actually kills or injures fish or wildlife, including significant habitat modification or degradation. So again, we see here, this prohibition on take really does show how the ESA works to protect both species and habitat. So very important, there's that prohibition on take. And then the other protection that species receive under the Endangered Species Act is this duty to consult, or this is sometimes called Section 7 consultation. You'll see that actually quite a lot. And this functions a little bit different than the prohibition on take. The prohibition on take is pretty straightforward, right? If a species gets listed, don't go out and actively try to harm it. That's a pretty clear violation of the ESA. This other protection functions a little differently because it requires federal agencies to take action. So under the Endangered Species Act, all federal agencies, right, every single one, is required to consult with Fish and Wildlife Service or National Marine Fisheries Service to ensure that any action they carry out, that the agency carries out, will not jeopardize listed species or destroy critical habitat. So once a species is listed under the ESA, if an agency is going to be carrying out an agency action that might result in jeopardy to that species, then the agency has sort of a duty to consult with Fish and Wildlife or National Marine Fisheries Service to make sure that they do not jeopardize that species. And in this instance, jeopardy refers to an action that is reasonably expected to reduce appreciably the likelihood of both the survival and recovery of a listed species. So, in essence, once a species is protected under the ESA, one of the many protections it receives is sort of this, duty that's placed on all of these federal agencies to ensure that their actions are not going to reduce the likelihood that that species will survive and recover so that it is no longer endangered. And it's this duty to consult that is really kind of the sticking point here when we're sort of talking about this whole issue, because it really does seem to be the area that EPA has sort of had trouble satisfying as it carries out its actions under FIFRA. But we'll get to that. As first, it probably helps to know what this consultation is. What is this duty to consult? What is the Section 7 consultation process? So again, this Section 7 consultation process applies to all federal agencies, to all actions they carry out. For this purpose, an action is defined as anything an agency has authorized, funded, or carry out. So that's pretty broad. It covers a lot of topics. If the agency has given the green light, if they've provided funding, or if they're actively carrying out the action, then they have a responsibility to fulfill this ESA Section 7 requirement. It doesn't matter what the action is or what statute the agency is sort of taking the action under, whether it's a FIFRA action or an action under some other law. The agency has a duty to fulfill this Section 7 consultation requirement from the ESA. So the consultation process is fairly straightforward. The first step is sort of referred to as it's referred to as informal consultation, and this is where the agency determines whether or not the action it's proposing to take will affect a species. So here, the agency is going to look at its action. It's going to sort of look at what the impacts are of its action, and it's going to make a determination as to whether or not the action may affect any listed species or critical habitat. And this is a very low threshold to clear. Um, may affect just includes any potential impact to the species. It doesn't matter what that impact is. So, what if an agency makes a finding that its agency action may affect a listed species? It then moves on to sort of this second part of informal consultation where it determines whether, what kind of impacts its action is going to have. And there, the federal agency is going to make a determination as to whether the action is not likely to adversely affect listed species or whether the action is likely to adversely affect listed species. If the federal agency makes a finding that yes, our agency action may affect listed species, but it's not likely to adversely affect listed species, the federal agency will go ahead, it'll reach out to the services, and it'll just sort of get some consultation there. And if the services agree that the action is not likely to adversely affect listed species, that's great, we're done. The federal agency has satisfied its Section 7 consultation duties, and because the services have agreed it's not that their action is not likely to adversely affect species, then the agency can proceed as planned. However, if the agency reaches a likely to adversely affect finding, that's where we're off to the races. In that instance, then the agency is going to reach out to the services and proceed to what is known as formal consultation. And just very quickly, I do like to put this up because I sometimes find that a visual aid is really helpful to illustrate this process. Um, we see here we start with the agency action. It's possible that, there could be no effect and the agency can go ahead and carry out that action totally as planned. That's fantastic. If the agency, however, has that may affect finding, it's going to do the rest of this informal consultation process, reach that not likely to adversely affect finding. If they do, that's great. No further action needed. They can go ahead and carry out their action as planned. However, if they've reached that likely to adversely affect finding, then they're going to move on to formal consultation and the development of a document called a biological opinion or a BIOP. So this is a very crucial part of the formal consultation process, the development of this biological opinion or BIOP. This is a document that is developed by whichever service is consulting, whether it's National Marine Fisheries Service or Fish and Wildlife Service. It's almost always Fish and Wildlife Service. Fish and Wildlife Service consults for all sort of terrestrial animals and freshwater fish. National Marine Service does sort of, as their name would suggest, they consult for marine animals. So for the most part, it's going to be Fish and Wildlife doing this. just they have more species to manage. So the biological opinion is a very detailed document. It's going to include a lot of information. I'm not going to walk through the entire sort of what the entire thing looks like, but I do want to highlight some very important things that come up in a biop. So first, I think that's not surprising. The biop will usually will always include a really detailed finding of sort of what the expected impacts to listed species and critical habitat are. And they're going to really outline what the anticipated impacts are going to be there. The biop will also identify what is called reasonable and prudent alternatives. So if they find that the proposed agency action is likely to result in jeopardy, then the biop will include these reasonable and prudent alternatives, which are essentially different actions that the agency can take that will still achieve. So back to these biop documents, they're going to include a lot of measures that are intended to minimize impact and avoid jeopardy to listed species. Once this document is issued, the consultation process is complete, and the federal agency that's sort of consulting with the services can decide what they want to do, whether they're going to fully adopt the biop, whether they're going to move forward sort of on their own, or even just reinitiate consultation. But it's important to know, the development of this biop is the end result of the duty to consult. So before we move on to talk about FIFRA and sort of take a look at where these two statutes are intersecting and sort of what EPA has done and hasn't done, I always like to mention very briefly the penalties under the ESA. As many folks are aware, the ESA is both a civil and a criminal statute, which does mean that certain violations can result in criminal liability. However, I always like to highlight it's usually very difficult to kind of trigger that approach. There's sort of two types of penalties that come in under the ESA. These are penalties for knowing violations. So, purposeful. Someone went out and they specifically decided, today, I'm going to violate the Endangered Species Act. And then there's sort of all the other violations. These are, violations that happen unintentionally. So it's these knowing violations that's where we see some of these larger penalties kick in. For knowing violations of the ESA, we can get civil penalties up to $25,000 per violation. For criminal penalties for these knowing violations, we can see penalties up to $50,000 or a year in prison. All other violations will result in civil penalties of up to $500. So keep this in mind when we talk about liability later. This is really what we're looking at. The big liability under the ESA, at least for private individuals, comes from these knowing violations. So that's can be a good thing, but we'll talk about that in a little bit. So FIFRA, this is one that folks are usually aware of what it is. So in general, before a pesticide can be sold or used in the United States, EPA has to register that pesticide product under FIFRA. Now, to register a pesticide under FIFRA, EPA has to make a determination that if the pesticide is sort of used as intended, it will not have unreasonable adverse effects on the environment. And the sort of term is defined as any unreasonable risk to man or the environment, taking into account the economic, social, and environmental costs and benefits of the use of the pesticide. And this is certainly very different from the ESA's may affect standard, right? When we are looking at sort of, does this agency action affect listed species? That's a very yes or no answer. The unreasonable adverse effects test is really more of a balancing test. It requires EPA to sort of weigh what are the costs, what are the benefits, and would any risk that using this pesticide creates, would it be unreasonable taking all of that into account? So we can see that in that regard, those two statutes are kind of at odds. And very crucially, registering a pesticide under FIFRA is an agency action, right? This is something that EPA authorizes and carries out. So it falls into that category, which means, if we're kind of following the through line there, anytime EPA is registering a pesticide under FIFRA, it should be initiating and going through that Section 7 consultation under the ESA. And that is not the only agency action that EPA takes under FIFRA. Few of them. Modifying a pesticide label, say to add a new use or to add new use requirements, that would be considered an agency action. Registering a new pesticide active ingredient would absolutely be considered an agency action. Re-registering a pesticide, carrying out the FIFRA's mandatory 15-year registration review, all of that would be agency actions that would require would sort of trigger that Section 7 duty to consult. So hopefully with that, it's kind of clear how these two statutes work and how they interact. I mean, the ESA has this Section 7 consultation duty that under FIFRA, it looks like that could come in a variety of places. So with that foundation, I want to kind of turn to sort of how we got here, because I do think it's helpful to understand what EPA is doing. It's not something EPA is doing in a vacuum. EPA has really struggled to fully engage in that ESA Section 7 consultation duties for all of its FIFRA actions. And this isn't me saying this. This isn't, plaintiffs in environmental lawsuits saying this. This is EPA saying themselves that this is something they have struggled to do. And over the years, and especially over the last 6 or so years, this has really resulted in a lot of lawsuits filed against EPA, primarily by environmental groups, saying that EPA violated the Endangered Species Act when it did XYZ FIFRA action and failed to consult. And because of how the ESA is written, it's very rigid in what it requires, and courts have interpreted that language very strictly. So almost always these lawsuits end in results that are favorable to the plaintiffs, whether it's a court ruling, whether it's EPA just settling the case. These lawsuits are almost always settled or really result in outcomes that favor the plaintiffs. So EPA's kind of gotten itself into this situation where it has a lot of these lawsuits coming in. It's spending a lot of resources fighting them or settling them. And it kind of results too in very insecure, or at least more insecure, pesticide labels. When you have courts that are now maybe able to make some of these decisions that can see these pesticide labels either sent back to EPA for further review or even completely vacated. So really, it's because of this that EPA has decided to kind of take this new policy approach in an attempt to sort of reduce the lawsuits, reduce the strain on the agency, and to create stronger pesticide labels that are more likely to hold up in court. This is not the first time EPA has done this. I'm not going to spend too much time on this, but I do like to highlight that this is not the first time EPA has attempted to craft a new approach to dealing with its Section 7 responsibilities when carrying out FIFRA actions. In 1982, EPA developed what it called the cluster approach, sort of group together pesticides that have similar uses and would then do one large Section 7 consultation for that entire group. In the 1980s, just in general, we also began seeing EPA issue what it's calling ESA bulletins. I like to highlight this in part because we're going to be talking about these bulletins quite a lot in just a little bit. These are essentially geographically specific bulletins that contain use restrictions or additional use requirements for certain pesticides that only apply in certain areas because endangered species are present. Today, EPA posts all of these on a website. In the 1980s, that was not a possibility. So EPA would issue physical bulletins in county offices, which meant that not everyone saw them. So that was not necessarily a very successful attempt at the time. In 1989, EPA launched what it called the Endangered Species Protection Program, where again, it was working to develop geographically specific pesticide use restrictions for what the agency deemed the most vulnerable species. And then in 2005, EPA switched to carrying out sort of Section 7 consultation on an action by action approach. So, a new pesticide action comes up, EPA would consult. However, it does not appear like any of these have really stuck or been as successful as the agency wanted. which has kind of gotten us to the situation where we are today. Again, over the last several years, we've seen mounting lawsuits filed usually by environmental groups against EPA for its failure to consult in Section 7 consultation when carrying out FIFRA actions. And just, I cannot stress enough how often these lawsuits result in favorable outcomes for the plaintiffs. I've got just a couple examples listed. I mean, this really is a drop in the bucket for the number of lawsuits we've seen, but I think that this kind of highlights, one, how successful these plaintiffs have been, and two, sort of how broad an approach they're taking. We've got one lawsuit filed in 2020 over glyphosate. In the following year, we saw a court actually vacate a new use for the pesticide aldicarb because of the lack of ESA consultation. 2022, we saw a lawsuit filed challenging the EPA's registration of the pesticide sulfoxaflor, again, for failure to do that ESA consultation. And then just last year, we saw another one of these lawsuits over Enlist One and Enlist Duo. So, we see these lawsuits getting filed targeting a wide range of pesticide products. And a lot of the time, the court does, because of how just ironclad the language of the ESA is, the court tends to side with the plaintiffs. And a lot of the time, too, EPA will admit that it has not done that ESA consultation. And usually once they've done that, I mean, it's, what are you going to do at that point? So I really can't stress enough that this is sort of how we got to where we are today. And I do like to highlight this, that where EPA is now between court-ordered consultation schedules from, court decisions and settlements, EPA expects that just the pesticides that it has been ordered by a court to go ahead and carry out ESA Section 7 consultation on will take it well into the next decade. So that is where we're at, and that's how we got here. With that, I'm going to go ahead and dive into taking a look at what EPA has proposed, and I'm going to do my best to explain it as clearly as I can. I know that it took me a little bit to kind of wrap my head around what the agency was proposing, so we're going to go ahead and walk through this and hopefully be as clear and concise as possible. So I mentioned right at the top that the main thrust of EPA's new policy proposal is focusing on what the agency is calling early mitigations. So these are use restrictions that are going to get added to pesticide labels with the intention of reducing impacts to listed species and critical habitat, with sort of the goal of reducing the number of future consultations that result in jeopardy findings or in findings of adverse modification to critical habitat. And this is part of what took me a little bit to get my head wrapped around, because I'm sitting here reading all this going, early mitigations. I don't see anything in the text of the Endangered Species Act that talks about early mitigations. And that's sort of where we kind of have our first sticking point here. What EPA is doing is not engaging right away in Section 7 consultation. What they are trying to do is modify pesticide labels now so that when those labels come up for consultation later on down the line, whether it's for adding another new use or for doing the sort of 15-year mandatory review that FIFRA requires for all registered pesticides, that then when EPA consults on those labels in the future, it will be less likely that the biops generated, kind of result in these jeopardy findings that are going to result in stricter use restrictions. So that is kind of the primary thing that EPA is doing, is focusing on adding in restrictions now to reduce restrictions later. So at the moment, EPA is working on creating these early mitigations in sort of two main ways. And actually, we've seen these ways before. So the first way that EPA is working on developing these mitigations is by grouping pesticides into broad categories, herbicides, insecticides, and rodenticides, and then developing mitigation measures that will apply across those categories. This is very similar to that early 80s approach where EPA was grouping together pesticides with similar uses and then consulting on those as a group. The second approach EPA is taking is to develop more tailored mitigation measures to address species that the agency considers particularly vulnerable to pesticides. So again, we saw this in their later approach where they were, I think in '89, when they were developing specific mitigation measures for particularly vulnerable species. So EPA seems to be kind of bringing those two methods kind of from the '80s to now. So we're still kind of in the early days of EPA rolling out this policy, sort of telling us what they're thinking. The first sort of the first look we have is at one of these sort of broad groupings, specifically for herbicides. So last year, EPA released what it's called its draft herbicide strategy. So these are early mitigations that EPA expects to include on all herbicide labels. So it's drafting these mitigation measures to apply broadly to all registered herbicides. Again, we see these mitigation measures falling into two main categories. These are mitigation measures that are aimed at reducing pesticide spray drift, and then mitigation measures that are aimed at reducing pesticide runoff and erosion. Again, we're going to see sort of most of these EPA seems to be expecting are going to be necessary across a pesticide's entire use area for those mitigations that EPA thinks are going to be necessary for a pesticide's entire use area. So anywhere where the pesticide is used, it's going to be including that in the product's general label. However, some of these mitigation measures are going to be geographically specific. And for those, EPA is going to be issuing these use bulletins. You may or may not be familiar with these already. This is something EPA has used before. These are, again, geographically specific use restrictions for pesticide products that are incorporated into the product's label with instructions informing the user to go check out EPA's website, Bulletins Live 2. I also wish this website had a better name. It doesn't. But so for some of those, the user is going to sort of be responsible for going and checking Bulletins Live 2 to see if there is a sort of bulletin that applies to their area. But I want to go ahead and take a look at the mitigation measures that EPA is proposing through its draft herbicide strategy. The spray drift mitigations it's proposing are a little more straightforward and kind of what you would expect. They're going to be proposing additional buffer requirements in the form of either windbreaks, hedgerows, hooded sprayers. They're also going to be proposing application rate reductions, just sort of depending on the level of risk in a particular area. So those are the spray drift mitigations that are getting proposed under this draft herbicide strategy. The mitigation measures that are getting proposed to reduce runoff and erosion from pesticide applications are a little more complex. You might have heard sort of in the kind of talk about this new policy, you might have heard of something about a mitigation menu or a point system. This is where we see this coming from. So I'm going to do my best to explain it. This also confuses me. There's math involved. I'm not happy about it. For these mitigation measures to reduce runoff and erosion under the draft herbicide strategy, the method that EPA has proposed is essentially for each pesticide product, say we've got pesticide product X, the agency would propose a number of points for that pesticide. So let's say it's 5 points. This is sort of the point, the amount of points that anyone applying the pesticide needs to meet in order to sort of apply the pesticide in compliance with the label. To get that number of points, EPA has identified a series of mitigation measures intended to reduce runoff and erosion. These are, pretty broad. We're seeing weather-based restrictions, restrictions on method of application, in-field management activities, all sorts of things. Each of these is sort of added to this menu, to this mitigation menu, and each of these has is going to have a point number attached to it. So some of them might be higher, some of them might be lower. And then if you are the pesticide applicator, and again, you're maybe applying pesticide X that requires 5 points to apply, you're going to go ahead and look at that mitigation menu and see what you can do on your field to achieve the desired number of points. If you are already doing some of these activities and it gets you up to the number of points necessary, EPA has been saying, we're going to go ahead and that will count. But it's possible that, an applicator might need to incorporate another mitigation method to sort of achieve the number of points for whatever pesticide it's applying. I'm hoping I've explained that relatively clearly. I think this is at least in my experience so far, this particular bit of it has been the hardest thing to kind of articulate, because I'm not aware of EPA doing anything like this in a similar circumstance. So I think this is a very new proposal. If you have any questions about this, we can talk about that later. But just broadly speaking, for the draft herbicide strategy, these are the mitigation methods that EPA is proposing. And again, EPA is developing these and expects them to be applied broadly across registered herbicides. So the other approach that EPA is taking, we've taken a look at the draft herbicide strategy. And I should mention, this is only the draft herbicide strategy from those groups that we talked about earlier. We've got insecticides and rodenticides still to go. We're expecting to see a draft insecticide strategy sometime this year. We don't yet know what it will look like, but I would wager that it will be somewhat similar to the draft herbicide strategy. But this is kind of a sneak peek at sort of what these, all three of these are going to end up looking like. So the other approach that EPA is taking here in developing these early mitigations is the Vulnerable Species Pilot Program. So this is the program where EPA is, instead of adopting or developing mitigation measures that will apply broadly across an entire group of pesticides, these mitigation measures are going to be more tailored to specifically address what EPA has identified as vulnerable species. These are species that are seen as being at the greatest risk of pesticide exposure. And because these are, more geographically tailored, they could appear on a variety of different pesticide labels, and they're going to be very geographically specific. These are going to be, this is where EPA is going to be relying very heavily on that Bulletins Live 2 website to incorporate these mitigation measures into pesticide labels. So just some terminology, areas where mitigation measures are going to be required under this Vulnerable Species Pilot Program are called pesticide use limitation areas, or PULAs. I'm going to try not to use that term too much in this webinar, because I think it's just getting a little bit into the terminology. But if you're, kind of, as you sort of delve further into this and start hearing more about this policy program, if you hear about PULAs, that is what those are. Again, we're seeing our mitigation measures kind of be divided into two main categories of mitigation measures. Avoidance mitigations, or avoidance PULAs, would be areas where EPA will be prohibiting pesticide applications entirely. You might have heard last summer about a possible avoidance mitigation area that would cover a large part of Oregon's Willamette Valley, which is, for those of you that are unfamiliar with Oregon, that is a very big agricultural area for the state. That was a sort of potential proposal as part of this Vulnerable Species Pilot Program. The other kind of mitigation measures we're seeing under this program are minimization mitigations. These are mitigation measures that would focus, once again, on reducing spray drift and runoff or erosion. EPA has saying that it would expect the mitigation measures developed under this vulnerable species pilot program to apply broadly to conventional pesticide active ingredients that are used outdoors. So we would expect, while these mitigation measures will be geographically specific, we could expect to see them on a wide variety of pesticides. And then just once again, most of these are going to get incorporated into pesticide labels through these ESA bulletins on EPA's horribly named website, Bulletins Live 2. So much like the mitigation measures from the draft herbicide strategy, the mitigation measures that are getting proposed under this vulnerable species program, we've got our spray drift mitigations and our runoff and erosion mitigations. So for the spray drift mitigations, EPA is proposing, right, unsurprisingly, spray drift buffers, and then a prohibition on some application methods or droplet sizes. For the runoff and erosion mitigations, we are blessedly not seeing that point system here again, but we are seeing there could be restrictions on applications when soil is saturated, when rain is in the forecast, and then possibly the requirement of certain land use practices that are, again, designed to reduce runoff and erosion. So we still, again, don't necessarily know what the final what this program is going to look like in its final form, or when we're going to start seeing more of those restrictions appear on pesticide labels. However, late last year, EPA released kind of a brief update on this program, primarily to address comments that it received on the vulnerable species program during the comment period last year, and then to just outline a few next steps. And our primary takeaways from that update are EPA is planning to improve species maps that it's going to use in this pilot program. This is a positive thing. So as EPA is developing these geographically specific, pesticide use restrictions, it's relying on species maps from Fish and Wildlife Service. The problem is these species maps are not always up to date or highly detailed. Sometimes they're as simple as a description of the habitat that the species is thought to be found in. So EPA is planning to develop better species maps that are more specific, that do a better job of actually describing where the species is located before it starts to develop these mitigation measures. So that's a positive. EPA is also going to be revisiting how some of these vulnerable species are identified and selected. We actually don't really know right now exactly how EPA is doing that. So that's, hopefully we'll get some more information there as well. And then the final thing just to be aware of coming down the pike for this is that EPA is planning to provide further updates by the fall of this year. So we could get those updates earlier. It might not be until later, but we are expecting them sometime this year. And with that in mind, I'm going to go ahead just briefly about what else we're expecting this year as this program continues to develop. So for the draft herbicide strategy, there was a public comment period last fall that closed in October. And just based on that, EPA is expected to release a finalized version of the herbicide strategy this year. I've heard that it could be as early as this month. It's hard to say. Hopefully earlier so that we have an idea of what we're working with, but it's hard to say. After that, EPA plans to issue a draft insecticide strategy sometime this year. We don't necessarily, at this point, we don't really have a better idea of when, but sometime this year, EPA is expecting to issue a draft insecticide strategy. So I would, if this is something that you're interested in, keep an eye out for that. EPA also intends to continue developing mitigation measures and start introducing bulletins for the 27 species that it included in sort of this first pass at the vulnerable species pilot program. The agency also plans to expand the program to include more species. So that's something to keep an eye out for. And just very much right now, we are unclear on when all these mitigation measures will begin appearing on pesticide labels. It's not clear what EPA is planning for the rollout, what the timeline is, and when we can expect to see these, which is always fun and exciting. So having gone through all of that, I've as I've started talking about this new policy with folks, there are some, I think, important questions that are, legal and practical, um, come up a lot that I think I like to end on, just to kind of get people sort of thinking about this. Um, I think the first thing that we have to ask ourselves is whether or not this new policy sufficiently satisfies EPA's Section 7 consultation duties. As we've discussed, and I hope I highlighted, EPA, this policy isn't actually about Section 7 consultation. This policy is about introducing early mitigation measures to reduce the likelihood of jeopardy findings in future Section 7 consultations. So with that in mind, I think we have to ask whether this policy actually satisfies EPA's ESA duties. I don't know that we have a solid answer on this yet. I don't know that we have a solid answer on any of these questions yet, but I think it's really important to be asking. And I'm sure that we will probably see other people asking it as this policy kind of rolls out. In the same vein, I think there's questions as to whether this policy meets FIFRA's unreasonable adverse effects standard. Is EPA, as it modifies these pesticide labels, appropriately doing that balancing test? What happens if some of these pesticide labels conflict with state law? We've talked a little bit about those species maps. I think there's questions about, if we have mitigation measures drafted on insufficient species maps, what happens there? There's liability questions. And I think very importantly, there's questions about whether farmers are more vulnerable to ESA lawsuits. We took a look at the penalties under the Endangered Species Act earlier. A lot of those are very difficult to prove. Very high threshold to clear to actually get penalties against a private citizen under the ESA. But the ESA does allow for citizen suits. So it allows for private citizens to sue anyone they want under the ESA. So there is some question as to, is this going to open farmers up to those kind of lawsuits in the future? For all of these questions, unfortunately, my answer right now is I do not know. I don't think anyone knows, but I think these are issues that we will see come up as this policy continues to get rolled out and as people start really sinking their teeth into it. So with that, that is the end of my presentation, and I think we should have about 10 minutes left for questions.
Right. So thank you, Brigit, so much. That was a great talk. I know we're getting into the weeds on some of this stuff, and that's exactly where we need to be. Before we move to questions, I do want to highlight that this is a Illinois soybean growers webinar. And Illinois Soybean Growers is a membership supported organization that works for advocacy on behalf of Illinois farmers in Springfield and DC. It works in partnership, but on different issues than the checkoff, and that membership piece is really important. So if you are not already an Illinois soybean grower, I just want to encourage you to follow the QR code and look at becoming a member. That said, we do have a panelist to help answer questions. Brigit, of course, will take lead, but then we also have Kyle Kunkler from American Soybean Association and Ashley Smith, who is part of Tory Ag Advisory Group, which is our consultants in DC, or the Illinois Soybean Growers consultants in DC. So I encourage everyone to go to the QA if you have questions and submit questions, and I'll give everyone a minute to do that. Do you just want to go to the question slide, I guess, Brigit?
Absolutely.
And if you don't have questions, believe me, I have some. So we'll have great discussion.
Good.
First question popped up. Where in Illinois will this have the greatest impact?
Yeah.
I look out the window and struggle to think of what could be the nearest critical habitat for an endangered species. I hate to see the tail wagging the dog.
That's a really good question. Unfortunately, I'm not going to be able to answer it, but I think that does kind of get to this idea of species maps, right? Again, that's going to be most applicable in that vulnerable species pilot program, the mitigation measures that are developed there. But there are a lot of questions about, are these, where specifically should these mitigation measures be introduced? And, how broad are we going? I think for the draft herbicide strategy. So for the mitigation measures that are getting developed across that sort of these entire groups of pesticides, the issue there really is sort of reducing pesticide traveling off the application site, right? These are all mitigation measures designed to reduce spray drift and designed to reduce runoff and erosion. So to me, it seems that what EPA is trying to do isn't necessarily saying, all these fields are filled with endangered species. It seems that the sticking point really is trying to reduce pesticide traveling that would, travel off field and impact species that are found off site. But that question of where are these species actually located is a really big one, and certainly came up a lot after, particularly after EPA made that announcement last summer that it could see large parts of the Willamette Valley in Oregon be off limits.
Yeah, so I'll jump in there. When I think about this, one example of how this will impact regionally, the vulnerable species pilot. The rusty patch bumblebee was one of the protected species in Illinois. And it is highly concentrated in northern Illinois, kind of around the Chicago area. And I would encourage you to think about it from the perspective of where there are woodlands or waterways, there are more likely to be some of these endangered species. And so that is a big part of this challenge, locating it and stuff, but are locating where you are in relation to these endangered species is going to be a large challenge. But there are big areas of northern Illinois, western Illinois that will be impacted. And this is great. I'm seeing a lot of other questions come in, so I'm just going to jump.
Corey, do you mind if I make one more quick point on that as well? That question?
Yeah, go ahead, Kyle.
To I want to make something abundantly clear, and I think Brigit alluded to this earlier in her presentation on the herbicide strategy, but everyone will be impacted by this proposal. If you're an agricultural herbicide user in the lower 48 states, you will almost certainly have a compliance obligation. EPA offers exemptions in the proposal if you're not near if you're 1,000 feet from what it calls aquatic or terrestrial habitat, but they define habitat so broadly that virtually everything is included if it's not a farm, field, or road. And so, figuring out, an area that's not 1,000 feet from one of those is virtually impossible. So the question then is what's your requirements going to be? And there's a base level of requirement for everyone to adopt certain restrictions, spray drift and runoff erosion requirement under that proposal. But if you're in one of their pesticide use limitation areas, the PULAs that, Brigit wants to dodge that term, and I agree, it's a tricky term, but half of Illinois is in those PULAs, particularly northern and western Illinois. And if you are in one of those areas, and it's a pretty broad swath of the state, you would have heightened regulatory requirements, which would require you to adopt even greater number of runoff and erosion mitigations.
Yes,
thank you, Kyle.
Absolutely. Everyone will be impacted by this. I've seen some really great questions here, and a couple of these I can run through pretty quickly. So there's a question about, well, a final strategy will be permanent relatively soon. Isn't it true that individual label changes won't occur until each product's re-registration? I can understand where you would think that because FIFRA is very complex, but that is not true. EPA can actually go in and modify pesticide labels sort of as it wants to. And sometimes that's really good because it means maybe it's adding a new use for a pesticide that wasn't registered before that opens up uses for that. Sometimes it means we get additional use restrictions. It's sort of a mixed bag there. How would you respond to the expected farmer response of no one enforces this, so I'm not going to change my practices? That's a question I've been getting a lot. I think, you can't make someone do something, right? Like none of us have that power. But I think the response there, like with most, kind of questions about why should I follow this pesticide label, is that, well, under FIFRA, right, a registered pesticide label is the law. So, well, it's true, it's not always easy to show that a pesticide label was violated or show, who did who made the violation. if you violate a pesticide label, you are violating FIFRA, you're violating federal law, and opening yourself up to that kind of liability. So that would be my response to that. Following our nearest habitat question, we all need to be concerned with pesticide availability. Yeah, I agree with that. I think that, you know, as this is coming up, as this issue progresses, it's going to be a really good idea to be aware of pesticide availability and how this is going to impact new products and new uses for existing products. How is the manufacturing industry responding? That is a great question. I've not had the opportunity to talk to as many people on the manufacturer side as I would like, but I do know that a lot of the manufacturers are, they are working with EPA on this, you know, because they are trying to do their best to protect their products and to make sure that their products get out to you. So they are working with EPA so that they understand what their obligations are and to try to make those obligations as, you know, is easy for them to meet as possible while still sort of complying with the law. So they're working with EPA on this and they're kind of doing it from that perspective.
Brigit, let's let Kyle, do you want to jump in on that question? I know you work a lot with
Yeah,
the
I would
industry and the manufacturers.
love to hear what you've heard.
Yeah, I mean, thankfully, many of them have similar concerns as we do.
Yeah.
You know, we're relatively in lockstep with many of the manufacturers and registrants. They want customers to be able to use their products reasonably, and they have some anxieties collectively. The community has anxieties about these types of restrictions. You know, placing potentially unnecessary burdens on their customers. So we're working pretty closely with them to make sure that you know, any sort of resulting, you know, something that gets finalized at the end of the day here is actually workable for agriculture.
There's a question in here about how this is going to affect the approval process of a new herbicide. Is it going to add time to the process? Yes, absolutely. And so I think there's two pieces to that. One is as EPA is going through and developing these early mitigations and incorporating them into pesticide labels, I think we're going to see that certainly add time to the approval process, but also for a brand new pesticide that has not been registered before, EPA is trying there to increase its Section 7 consultation compliance, and those consultations can take quite some time because EPA has to coordinate with Fish and Wildlife Service. It might need to get more information from the manufacturer, the registrant. So that can take quite a bit of time, which is in part why EPA has been maybe a little lax on doing that in the past. So I would expect that as EPA does those Section 7 consultations, it will take longer to get new pesticides approved and fully through the process. I don't know, Kyle, if you've heard anything differently.
No, I mean, I was just
gonna Kyle, hold up. Let me jump in. It is 8 o'clock. I just want people to be aware. Our panelists, I'm happy to stay on. I think several of our panelists are to help continue answering questions for at least a little bit. So no need to jump off, but I did want to flag that time. The other thing I wanted to highlight, the industry question we had earlier. We do have some industry people on today, and also we are going to hold a webinar later in the season where the industry is going to be able to kind of speak on what they're seeing on their end. So that industry piece is important. I do want to highlight that as an Illinois soybean growers, we value our industry partners and we really want to hear from them as well. That said, Kyle, go ahead.
Point's very well taken, Corey. The one other thing I would say, and Brigit hit on this earlier when she was sort of talking through sort of the foundational ESA and FIFRA processes. You know, keep in mind, you know, ESA it affects every federal agency. So if Department of Transportation wants to build a bridge across a creek and there is an endangered turtle, that's a relatively quick action to determine whether or not that turtle is going to be impacted and if there's any sort of, you know, reasonable and prudent measures or alternatives that need to be done to make that turtle not impacted. But when you're talking an herbicide that could be registered for dozens of crop uses across hundreds of millions of acres and may intersect with all 1,600, you know, federally listed species, like that's an entirely different question. It's part of why, you know, EPA has not historically, you know, fulfilled these obligations. But you know, to that question of whether this is going to add time, just think about it in that, you know, in that frame. Hundreds of species, hundreds of millions of acres, and you're not doing it for just one active ingredient, but hundreds of active ingredients.
Yes, I think that's really helpful to illustrate how much effort goes into doing that Section 7 consultation for registering a pesticide. Like Kyle said, if Department of Transportation wants to build a bridge that might impact, say, a turtle species, maybe it can move that bridge. When we're talking about pesticides that are going to be applied perhaps in every single state in the lower 48, we're off to the races. That is a big jump up, and that is part of why these consultations in particular over pesticides take so long. I'm happy to stay on for a few more minutes, at least to kind of clear through the couple of questions that are left here. Someone is asking about what does adjacent mean? And this is the most lawyer answer in the world, so I am sorry, but it does depend. When EPA, when Fish and Wildlife Service, when all these laws are using adjacent, that could mean different things in different circumstances. It's just one of the fun things about legal definitions here. So what adjacent is going to mean in different, it could change depending on where the term is being used, how it's being used. I see Kyle doing a lot of this because that's unfortunately, it's very context specific.
I think that really highlights a lot of struggles with this whole, what we've seen so far is there's terminology without definitions or with very wide ranging definitions that it just creates a lot of complications and confusion for our growers. And that's something that we're as ISG pushing back at the EPA on and saying, hey, we need more clarification.
Yeah.
And then, I see this other comment, we often spray before rain when the EPA says you can't spray, and that's reference to the 24-hour or 48-hour rain restrictions. I've had some conversations myself with the EPA, and I think that some of this stems from they're trying to apply, at least with the herbicide strategy, they're trying to apply a broad range of rules to a lot of different farming practices, and they don't have clear insight initially on how we farm, especially in Illinois, and that's an important part of this message. That's a great point. We do a lot of pesticides go down within 48 hours of a rainfall event. And that's because that's the only time, if we don't get it down, then we're not going to be able to do what we need to do to protect our crop.
Right. I think both of those questions, both the adjacent and the rainfall question, highlight sort of a broader concern here. And that's that we've got probably, the grower community collectively has 20 or 30 buckets of questions about how this is going to work that we just don't have answers to.
Yeah.
We've been engaging with the agency. We've been following up. Illinois soybean growers have been fantastic partners in this, and I know we're engaging with EPA frequently on this topic. Many in the grower community are. That we're working to still get answers to, and there's just currently a lot of holes as to how this is going to work that need to be addressed before finalization of any of these proposals.
So there is one question that I think kind of will spur a little bit more conversation. This sounds like an attempt to shift the liability from lawsuits from the EPA to the farmer. I don't know if I fully agree with that statement. It is a response to lawsuits by the EPA in their attempt to avoid additional lawsuits. That's 100% true. What I'm not sure of is it their intent to shift that to the farmer? Because one thing that's important to understand is it's not really clear who's liable in this whole conversation. The farmer, the applicator, the landowner,
the pesticide registrant.
Yeah, the registrant, like it's not clear at all. And that's a major question. I think, I know Illinois Soybean has sent in to the EPA and asked them multiple times and hasn't got a satisfactory answer. Kyle, I'm pretty sure American Soybean has done the same thing. That's a real challenge. But I did one thing I like to remind people is the EPA kind of fought this for a long time in the courts. And they are now court ordered. This is something they have to do. And so it's easy to make the EPA the boogeyman or the bad guy. But I'm not sure that that's the correct characterization of the agency. I don't know that they're necessarily the bad guy. And I'd love to hear the panelists' comments on that thought.
I agree with you that I don't think that, I'm not in the room with EPA, but I don't think this is them purposefully attempting to shift liability. I do think this is them sort of responding to a growing problem that they have been dealing with for decades, really, that just in the past few years has really come to a head. I would also say that in my experience, the environmental groups that bring these lawsuits are usually more interested in filing suit against the government or against pesticide manufacturers than against specific farmers. And part of that, is the scope that those groups operate at. But another part of that is the difficulty of proving the liability of an individual farmer. It is hard enough right now to prove, if someone misapplied or violated a FIFRA label by misapplying a pesticide, as it stands now. I don't necessarily think that it would get easier to prove liability with these new restrictions in place. And for the ESA in particular, that's part of why I brought up that penalties slide. The EPA the ESA does make you work for it to kind of hit that penalties mark. You have to get those big penalties, you have to really show that someone was purposefully violating the Endangered Species Act. And that is a harder thing to do than it sounds. So I think that is hopefully, maybe not comforting, but hopefully can be helpful to keep in the back of, your mind, especially as this gets unfolded, is that it's going to be very hard to show that an individual is liable for a violation. I think that the bigger question is, if environmental groups ultimately kind of take the position that this policy approach does not satisfy EPA's ESA Section 7 consultation duties, will they continue to file suits? And what will courts do with that? I think that is the bigger issue. Could we be in a situation where now we have these additional use restrictions on pesticide labels, and we're still getting lawsuits that are overturning pesticide labels or sending them back to EPA for further review because these Section 7 duties still aren't being met? I think that is the bigger concern.
Ashley, I saw you go off mute. Were you about to say something?
Yeah, and I think you're probably going to hit it when we go to the next question. So I will let you go ahead and answer that, and then I'll chime in there if I have any other thoughts.
Okay, so I think if we go down here, one question that popped up that's are there similar regulations guidelines anywhere else in the world? Yes, there are. I'm not an expert, so I will welcome someone else to comment there.
I would say I'm not an expert on international law. I do not know what other areas are doing, but the EU has some pretty strict pesticide restrictions over there. They have bans on pesticides that we don't. There other places do things differently. It really just kind of depends on where you are. But, the Endangered Species Act is certainly something that's unique to the United States. So that probably is going to generate some things that are just unique to us.
We definitely see similar conversations, bans, and regulations, especially in places like Europe. There's a lot of fighting over glyphosate in Europe.
Yep.
We also, if we don't take it internationally, but look at the state level, we do see a lot of pesticide regulation that's really unique. And I'll just highlight here in Illinois, just last week, Springfield opened up for business, and we saw a complete glyphosate ban for the state getting introduced in Springfield, which if you're a farmer, you probably realize that glyphosate is an important product for protecting our crops, but this would also apply to urban use as well. And so there is a lot of things happening in multiple places for sure.
Yeah.
Kyle, did you have anything international to comment?
No, I mean, the only thing that I would mention is that something that is just on our mind is not necessarily places that do have these rules, but places that don't. And particularly thinking about major competitive markets with the United States. You think South America, Brazil, Argentina. And I mean, candidly speaking, from our sort of high level awareness, these types of, rules and protections don't exist in places like that. And we do worry and sort of have medium to long-term anxieties that these types of rules could place U.S. producers at a significant competitive disadvantage.
That's a really good point. And I've heard Brazil get mentioned quite a bit in these discussions.
So last question, I think it's a really good place for us to wrap up is what is the Illinois soybean growers strategy to push back or work with these proposals? And I think that really there's a multi-prong approach as we kind of move forward. One strategy is we're engaging directly with the EPA. We've met with them in person multiple times. We've met with them virtually. In fact, next week, I am going with a group of farmers to DC to sit down with the EPA, and hopefully ASA will be there to join us as we work on that. A big piece of this is collaboration directly with American Soybean Association, and also bringing on our consultants like Toriad Group to help advise us in how to walk the pathways of DC to work to talk about these issues. And part of our mission also is to start bringing this up to our representatives in the Hill, for sure. And so there's a lot of different strategies. There is also some conversation about legal pushback. What can we do here? Can we organize a national front? Is there a state level need? And that is something that we're having internal conversations on and working on for sure. Because I do think that that's a big piece of the question. Kyle, I know you're working heavily on this. I'd welcome Kyle or anyone else to comment as well.
Corey, I think you hit on some good points. I won't delve into those. You covered those well. But the one thing I will say is that, there is a lot of skepticism of also the way that EPA makes these determinations as to whether species and their habitats are going to be impacted. They take a very, very conservative approach that operates on a lot of conservative models and conservative assumptions. And we think that those conservative approaches often overstate then habitats will be impacted, requiring growers to adopt restrictions unnecessarily. Don't get me wrong, we want to be good stewards and we want to protect the environment, but if it's not necessary to protect a species, we don't want to force unnecessary regulations on growers. Under the Endangered Species Act, all federal agencies have an obligation to use quote unquote the best available science and commercial data. And in these risk assessments, EPA, we don't believe is doing that. So we're working in part of that congressional oversight, and we've also been working with appropriators to direct EPA to revise their approach in a way that actually uses good science and data, and we think is going to result in much more evidence and science-based risk assessments that will only require restrictions that are truly necessary to protect species and their habitat.
And I think just to kind of chime in here, Corey, you made some really good points earlier on the work that ISG is doing. And I know Kyle Kunkler and his team at ASA is doing a lot of work around the Hill and, around agencies as well, just making sure people understand the implications of what's going on here. But I think to kind of put a finer point on some of that, it's really important to understand that like Corey said earlier, like Kyle talked about, like Brigit talked about, something is going to happen here. There is an obligation for, some action moving forward. And while this proposal is certainly not perfect, has some really, glaring challenges and things that would be problematic to agriculture, it's really important to remember that if ag's not at the table, giving feedback, talking to folks who are making decisions on this, it's going to be worse for us. So I think that sometimes, there's a want to just say, this isn't good for us, throw it away, get rid of it. But I think this is a really good opportunity for ag as a whole to come to the table and say, there are parts of this that really don't work for us. Let's work together and find out a path forward here so we can all be successful and we can have the tools to grow these crops that we're using to feed the world.
To that point, I will also say, keep in mind, Brigit laid out a really good slide earlier that showed the ramifications if EPA does not become compliant. The lawsuits will continue. We will continue to lose products, the court vacatur. We need EPA to become compliant with ESA. Really, the question is sort of the devil's in the details of what does it mean to be compliant? And that's where the rub's going to be.
Yep. For our part, the National Agricultural Law Center, we are not an advocacy group. We are neutral and bipartisan, but we are staying on top of this issue as all, as a new developments happen, we will be providing updates as quickly as we can and making sure that we are putting out resources so that all of you can understand what EPA is doing and sort of what it looks like is ahead. So do keep checking back in with us. If if we can help you stay on top of things, if we can answer questions, we are happy to do it.
Okay,
I
that
just wanna-
said, I think we can end the webinar. Thank you so much for joining us, everyone, and just give a round of applause for our panelists. And you will get a follow-up email, and there will be future webinars. Thank you very much.